Doug Burns, a former federal prosecutor, now with his own private practice, is back on the Inside Track. Doug, you know, we've been focused so much on the Roger Rotnam trial, but what's striking here is that we heard just yesterday, in fact, from the prosecution that the illegal profits in the Raj case amounted to $63 million. Here we're talking about almost half as much money.
Yeah, no, it's unbelievable. You know, the cases come in different varieties in terms of the way it sets up. And as you explained, I mean, this is a lawyer in a law firm who, by the way, is not an insider. He's somebody who comes into possession of inside information.
He went looking for this stuff.
Yeah,
he wasn't actually involved in these deals.
He went on the law firm computers to try to access information about mergers and acquisitions. And what's interesting, don't forget, is historically in the jurisprudence of insider trading, you have printers, others who come across the information. He then tips a middleman, the middleman tips the trader, and the trader trades.
Doug, you know what everybody is asking right now? What on earth were firms like Wilson Sonsini, Cravath, Swaine and Moore, and Skadden doing, leaving information on computers available to any attorney to just go and poke around in?
Well, yes and no. I mean, the man is the member of the corporate department. He himself, it's so funny, in some of the after-the-fact tapes, was saying, look, it's not going to look bad. It's just going to look as though I was accessing information on ongoing firm matters. But you're right. I mean, your question really is, should there be more internal controls? But
should there?
Well, with all due respect, though, I mean, lawyers are obviously held to a high ethical standard. These are some of the bad apples in the barrel, as it were. We've seen other cases with lawyers. Interestingly enough, one of the most famous insider trading cases of all, O'Hagan, was a lawyer in Minneapolis who made $4 million on a deal. And that particular case, O'Hagan extended the theory of insider trading to misappropriation.
Doug, would you want to represent any of these defendants? I mean, people are going to be reading about this, and they're going to find the same things that we're talking about now. As the noose tightened on these defendants, and of course they haven't been proven guilty, they talked about burning the money, they talked about pretending to spend it on prosecutors. Hey, how do you take that to a jury?
Yes, I would like to represent him, and if you could put my phone number up, please. But no, joking aside, Eric, I mean, this case, one distinction that's important is that these are after-the-fact tape recordings. In other words, in the Roger Rotnam case, they had a wiretap, so they captured discussions about the actual crime. Here what happened is the government approached the middleman. Right. He agreed to cooperate. He went back with a script, as it were, and tried to get them to talk about things that had already happened.
And the stuff is very compelling.
The guy says, look, if they look at my bank records, this is really going to be a tough situation. And then there's also they did meetings in Atlantic City to make it look like gambling would provide a cover. And then also there's money laundering and structuring. I mean, the case involves a lot.
What's the old saying? The cover-up is worse than the crime?
Oh, no question about it. Martha Stewart, Richard Nixon.
The list goes on. Doug, thank you very much. Our own white-collar crime expert, Doug Burns, on the latest insider trading case. Maybe doesn't rise to the Roger Rotnam level, but boy, it is another blockbuster, tarnishing the reputations of three of the nation's most powerful law firms.